Good. I want to spend a couple of minutes next speaking about the timeliness of bringing a claim in the FINRA Dispute Resolution Forum. So for customer disputes, the FINRA Code of Arbitration Procedure has a specific rule on when you must bring a case. And that's Rule 12206, and it sets forth what's called the 6-year eligibility rule. So it's not technically a statute of limitations. Instead, it's a rule allowing for a claim to be filed within 6 years of the quote-unquote occurrence or event giving rise to the cause of action. Now, you should note that even though respondents may well bring up statutes of limitations, which could be shorter than 6 years, it is actually that 6-year eligibility rule that typically governs the timeliness of a claim. Now, different states vary on whether statutes of limitations even apply in the FINRA forum. And New York, it does not have a definitive rule on it. Other states do, but in almost every state, you should expect that the arbitration panel will exercise its discretion to apply the rule essentially as it sees fit. So brokerage firms being sued will often argue that the occurrence or event for purposes of the FINRA eligibility rule is the purchase date of the investment at issue. However, that is not always true, and there's everything from the guidance that is provided to arbitrators to dozens and dozens of FINRA decisions to court cases interpreting the eligibility rule. Will say that, in fact, if there is an ongoing course of events that infects the entire brokerage-customer relationship, that in fact the event or occurrence may not be the triggering event for that 6-year period to begin to run. So, for example, where there are allegations of fraud, or whether it's misrepresentations or omissions after the initial point of sale, it may well be that the time at which that fraud was discovered, which could be many years after the sale of the investment, it may be that discovery of the fraud is what begins that 6-year clock running.